All right, good afternoon and thank you for joining us today, or thank you for watching this video if you are now watching live. Today we want to discuss some IRS controversies or some issues dealing with the Internal Revenue Service and when you owe taxes or something like that. About 2 weeks ago, if I'm not mistaken, we did a presentation of the LITC, did a presentation regarding tax preparation and what you need to have, documentation about the VITA program. So if you go ahead and also watch that and get some information through that webinar. In a couple of weeks, we're also going to be joining with the local taxpayer advocate from the IRS, talk about specific issues during the 2020 tax season. Of course, she has some information from the IRS that will be important to share and for you to also get some information and get educated. Okay, my name is Kathy Guerra and I am the director of the Low Income Taxpayer Clinic. So let's get started today. So today what I want to do is make sure that we understand and we'll do an overview of the IRS tax collections. What is a tax assessment? Notice and demands, in other words, all those letters that the IRS may issue regarding a tax responsibility or liability. The lien and levies, which is the IRS collection options that they have. Then we're going to talk about a collection due process and the hearing and what happens when the IRS wants to actually either file a lien against you or start a levy of your wages or your bank accounts or whatever you may have and any asset that you may have. And then we'll talk about collection alternatives. So those ways that you can work with the IRS to pay what is owed rather than having them go ahead and take a lien or place a lien or a levy on your assets, okay? So let's start. So how does this whole thing start? Of course, there are two ways that the IRS can go ahead and start assessing or saying that you owe taxes. One of them, which is not listed here, but it's if you file a tax return that shows a tax liability. So you go to your tax preparer, you do it yourself, and at the end, it shows that you owe, let's say, for example, $5,000. You don't have that in the bank, so you go ahead and file your tax return, but you don't send payment. So that's one way. And the second one is where it says, oh, there's three areas. The first one is a math error. What does that mean? You send you file your tax return, you think everything is right, and then you get a letter from the IRS saying, hey, we have some documentation that was sent by your employer, let's say, and you forgot to include that income on your tax return. Or it could be that you filed a tax return jointly, or you claim a dependent and the Social Security number on the tax return does not match the IRS records. And now the IRS is saying, look, you're claiming this credit, or you're filing jointly and getting a higher standard deduction, but that Social Security doesn't match, and therefore we need to make sure and we change it. With that math error notice, they will give you 30 days. So what they say is we're proposing changes to your tax return according to the information that we have. It's a proposal, you don't owe the money yet. And then we'll talk about a little bit later what to do, but that is your time if within those 30 days to respond and say, hey, IRS, wait a minute, that income that you're saying that I did not report, I actually did not earn that. I don't know, I never worked for for this company. So now it's your job to call the IRS and to communicate with the IRS to respond to that letter and say, no, that's not me. Or if it's an error of a Social Security or date of birth or whatever it may be, it's an easy fix because you go ahead and just make those changes and that's it. And those proposed changes to your tax return will actually, they'll process your tax return without making those proposed changes. The second one is an examination. Examination, an audit, whatever you want to call it. And there's three types of examination that the IRS does. I guess pre-pandemic. Right now, we're still dealing with the COVID-19, and the IRS offices are still, and the employees are mostly working from home. But the examinations are this. Correspondence examination, meaning that you get a letter from the IRS requesting documentation saying, hey, look, you claimed that you have a small business and that you had, let's say, for lack of a better number, $1,000 worth of mileage that you are deducting from your income. So we are going to ask you for some support or some documentation that supports that claim. Also, another one that happens very often is with, if you claim your children and then you have earned income credit or child tax credit, and the IRS says, hey, look, you claimed this dependent and you're claiming all these credits. Now we want you to send some documentation. So everything is done by the mail. You get that letter, they tell you exactly how many days you have to respond. You gather the documentation that you need, and then you go ahead and mail it out. The problem with the correspondence examinations, unfortunately, is that you don't get one person who's assigned to your case or to your examination, to your audit. So it's whomever opens the mail that day at the IRS who's going to get the documents that you submitted, and they're going to make a determination whether to grant or to disallow whatever credits or deductions you had claimed on your tax return. And like I said, the problem is that you just don't know. I have experience that we're dealing with taxpayers who's they have 2 years of tax returns under audit or under correspondence examination at the same time. We'll submit the same documents for 1 year and submit the same documents for the other year. And one IRS employee will say, or agent will say, oh, that's enough to meet your burden of proof. We're going to allow all the credits and all your deductions. And another IRS agent may say, no, that's not enough. We want more documentation. So that's the problem with the correspondence examinations. Another one, like I said, and once everything goes back to some type of normality, we have in-person IRS examination when you actually are called to go to the IRS with the documentation that they're requesting. You'll get a letter saying, look, we're doing an examination of these items on your tax return. They'll be very detailed as to the items on the tax return that are being audited or under examination. And they're going to be asking you to submit some documents. And after that, go ahead and schedule a conference. I know in Naples, the closest IRS office is Fort Myers, and then the next one, it would be in Broward. So most of this can be done on a conference call, but you have one person, one IRS agent who's assigned to your case. You're dealing with that one person, you're calling them, they're calling you, and you're having that type of communication back and forth. So it makes it a little easier, especially because you're not speaking to a person, not just mailing things out and hoping that the person who opens it at the IRS, looks at the documents the same way that you want them to look at the documents. So that makes it a little bit easier. Also, the last one is the examiner or the IRS agent actually goes into your, and it's usually for business. Haven't seen any individuals or anything like that unless you're claiming Schedule C, which means that you are an independent contractor or you have a small business. They go into your office. They want to do an inspection of the building. They want to see, some type of the deductions that you have. They want to see a inventory. They want to see Excel spreadsheets. They want to see your books, how you keep track of your accounting. So that's a little bit more in depth than the other two. But individuals, usually you do the correspondence examination, or like I said, you go ahead and have that one in-person meeting at the IRS. And the last reason or the last way that the IRS can go ahead and start the collection or saying that you owe money is by doing a substitute for return. What does this mean? Let's say you forgot or you haven't filed your tax returns for a very long time. And the IRS will send you a letter saying, hey, look, in 2018, we have record that you have a filing requirement. You still haven't filed that tax return. So we are going to give you an opportunity to file one. If you don't, then we are going to use the information that was reported on by employers, by financial institutions, by all these people that you received income from, and we are going to be creating a tax return on your behalf. What happens with this? Of course, if you're married, the IRS is going to file a substitute for return as if you were single. So you miss out on some credits and you miss out in the bump in standard deduction. If you have any 1099 miscellaneous or self-employed income, the IRS doesn't know what your expenses are. They just know the income that you received. So they will go ahead and just make the substitute for return with the income with no deductions. So you're likely to have a liability rather than being able to utilize those deductions to decrease your income and decrease your tax exposure. So like I said, these are the three main ways that the IRS has to start the collection process, or in other words, saying that you owe money: the matter of the examination and the substitute for return. So once the IRS starts this procedure or this process, whichever one it is, then if you don't respond, they're going to, or something happens or your consent, then there's the tax assessment happens. So what are the ways that an assessment happens with the IRS? The first one is that you go through the entire process, you provide documentation, you do everything, and then the IRS says, look, we are going to be adjusting your account, and we're going to be disallowing this deduction or this dependent or this credit, whatever it may be, and then you don't respond to the IRS. So now there's a notice of deficiency that's issued saying, look, before we were proposing the changes, now we're saying that these are the changes that we're going to be making. You don't respond, boom, the tax assessment happens. Another way is with consent. You say, look, IRS, I did forget to include that income. I never received the documentation, and therefore I did not add it to my tax return. It wasn't that I was trying to commit fraud or anything like that. It's just I forgot. So I'm going to say, okay, I owe you the money. Another way that tax assessment happens is if you actually fight the IRS. You go through the examination process, you do all that, then you go to the appeals process, which we're going to talk about very briefly. And then you say, hey, IRS appeals, you're not seeing it the way that, according to the law. So I'm going to take this case to the tax court. And you go through tax court, and the judge also doesn't rule in your favor, and then the tax assessment happens. And of course, the last one is going through other court decision. Tax court is the primary way that you can go ahead and get an independent forum to listen to your case when it comes to taxes. And that's the main way, because you don't have to pay the tax liability that the IRS has assessed. So let's say you go through the examination, the IRS says that you owe $5,000, and you still fine and say, I don't owe you the $5,000. Here are the documents, everything, and then you don't have the means of paying the $5,000. So you petition the tax court to listen to your case. You don't have to pay a penny. You can do that, and then a judge will listen with IRS counsel, and you guys will have a trial. And then if the tax court judge agrees with you or agrees with the IRS, a decision will be made. However, with other courts, same scenario, $5,000, then you have to pay the $5,000 that the IRS says that you owe, and then you file in circuit court saying, hey, it's for a refund of the $5,000 that you paid because they were incorrectly assessed. A lot of course, of the taxpayers that we work and we represent don't have that means, but it's usually district court or circuit court is a little more friendly and more taxpayer friendly than sometimes than tax court. So that's another option there. So once there's an assessment, once either you accept it or you default it, you go to tax or whatever it is, then the whole IRS collection procedure begins. And what's important to know is that date of the assessment. So if it's in one way that you can know, you can always call the IRS. I know calling the IRS is always time consuming. That's why you should get representation if you can. If you meet the criteria, we'll be more than happy to represent you. But you can call the IRS and ask for what is called an account transcript. An account transcript will tell you exactly the date of the assessment. And why is this important? Because that's the date where the collection statute of limitations starts running. The IRS only has 10 years. I say only, but the IRS has 10 years to collect any past due taxes from you. So you need to know when the clock starts, because the IRS has those 10 years. There are things that you can do to stop the clock, and there's many ways. So I'm not gonna go in depth. I'm not gonna talk about those. But like I said, it's important to know when the assessment happens. For example, I have clients who tell me look, I know that I owe taxes from 2009, let's say. And, I asked, did you file your 2009 tax return timely in 2010, meaning because April 15, 2010, they tell me yes. And no, I haven't done anything. I haven't never responded to the IRS. I've never made any payments or whatever it is. Then I kind of sort of know, and I'll still go ahead and request an account transcript that the IRS has until April 15, 2020, meaning this year, to collect. And since they couldn't collect, the amount of the assessment goes away. So that's why it's important. And there's another thing, once the assessment happens, is that all the notices happen. All the letters from the IRS almost on a monthly basis start coming in. And a lot of my clients come in with unopened IRS envelopes. It happens all the time. They're too scared to open them themselves, and they think that, coming to me and I open the envelope, that I go ahead and have better news from them, or I can change what the notice says. But it's important to open those envelopes, and I will tell you why later on, because the IRS has a lot of power to collect what you owe. So if you are not keeping track and you're not reading these notices, the next surprise can be that the IRS starts taking a percentage of your Social Security benefits or of your wages or in your bank account, financial investment accounts. And so that's why it's so important. I know it's scary, I know the IRS, but the more you know, the less scary the IRS becomes. So this is we talked about what happens, or how can the IRS start an examination or start making an assessment of your tax return once the tax assessment actually does happen. And then now we're talking about the IRS Collection Tools. So what is it that the IRS can do? Okay. And I'm talking about the two most used tools. Another one that is not here, but I'll discuss is, of course, the offset, the use of your refund to offset any past tax liability. Example, I file my 2020 tax return. I claim, let's say, 2 children on my tax return, and I am due a refund. And let's go back to that magic number of $5,000. That's been the example through this webinar of $5,000. But I actually filed a 2017 tax return where I owe $3,000. So what the IRS will do is go ahead and from the $5,000, they'll reduce it by 3, pay off 2017, and go ahead and issue the remainder, the $2,000 to me. If I have another year, let's say 2017, and I had also liability for in 2018 for $2,000, then they'll go ahead and offset $3,000 for 2017, then they'll use $2,000 for 2018, and I don't get any of the 2020 refund. So that's one way, that's a collection tool, if you can say, that the IRS has. The other two are, one of them is a lien. Okay, so the government can, to protect its interest, because you owe money, put a lien against the taxpayer, against you. And the other one is levy. And I'm gonna go talk a little bit more in detail about these two. So a lien, a federal lien. Most of my clients, and I think a lot of taxpayers, have the misunderstanding that a tax lien only attaches to the home. So if they say, look, I don't have a house, so I don't care if the IRS files a tax lien against me, without understanding that a tax lien, a federal tax lien, attaches to all property, from your car to your real estate to securities, to every single thing that the taxpayer has and owns, that tax lien attaches to. Okay, so it's not just the real estate. And also it attaches to any property that is acquired or purchased or received after the tax lien is placed or is filed with the county. So example, I owe the $3,000, or let's say it's $10,000 to make it a little bit more correct, or making it correct. So I owe $10,000 for 2017. I'm not doing anything to pay that off. The IRS sends me a letter saying, hey, look, if you don't do something, you don't work with us, we're going to be filing a tax lien against you for 2017. Let's say I received that letter in 2018, then I purchased a new vehicle or a new home in 2020. Just because that was purchased after the filing, it doesn't mean that that tax lien is not going to attach to that property. So just have to be aware of that just because you purchase or you acquire the asset after the lien is placed doesn't mean it does not attach to that, okay? And it goes back in time as well. So usually examinations take a very long time within the IRS. So the year that you owe is 2010, but the assessment wasn't done because you went through the appeals process, maybe you went to court. It wasn't actually assessed until 2015. Well, the lien goes back to 2010. So it attaches from the moment that the tax return was due all the way until the amount is the IRS either cannot collect or you've paid everything, okay? And so, and like I said here, the lien remains in force or can be enforced against you until the either you pay off the amount that is owed, or the statute of limitations or the 10 years have expired and that tax liability becomes unenforceable. So now that tax lien unattaches to your property. And so a tax lien is the IRS is going to take this step when you owe more than $10,000. So if you owe over $10,000, and it could be in multiple years, it doesn't have to be 1 year you owe $9,000 and the other year you owe $1,000, and you say, oh, I'm fine because I don't owe in any 1 year $10,000, but in total you do owe $10,000, and the IRS can go ahead and file a lien against you. It is filed in county court. So it is public record. Anyone who runs does a public record of your name, it is, that IRS federal tax lien is going to appear there, okay? It also prevents taxpayers from selling those assets once that tax lien attaches. A good example is real estate. Since it is a public record, when you're trying to sell a house and you have a federal tax lien, you actually have to request a discharge of the lien for the property itself. And of course, the IRS is not just going to say, look, you have a bunch of equity on your home. We're going to discharge it so you can sell the lien, so you can sell the home. Of course, it's not that easy. You have to show that you have a means of dealing with your tax liability, whether it's using the equity to pay what you owe, or entering into a payment plan, doing some type of collection option. Once you can prove and show the IRS that there is a way that you are going to be paying off the tax responsibility, then they'll go ahead and discharge that lien. Just that property gets lifted, you can sell the assets, and then you have to go ahead and follow the contract with the IRS. Okay, and the reason that they do this, of course, and it's a public record, is because the IRS or the federal government wants to say, look, we're the government, we are the IRS, so we have priority over some other creditors. Not all creditors, but some of the other creditors that you may have out there. Levies. Levies is pretty much the IRS either asking your employer to send a portion of your salary to them because you have failed to either enter into a payment plan. And of course, this is all these collection options happen only if you fail to respond and to work with the IRS. If you're working with the IRS and you're trying to resolve your tax issues, then these two, the liens and the levies, the offset of the refund is going to happen even if you have an installment agreement or a payment plan. But the liens and levies are the tools that the IRS uses when taxpayers completely ignore letters. They're now working with the IRS, and they feel like this is the only tool that they have. So like I said, going back to the levies, they can take a portion of your wages and salary and they can get up to 15% to go ahead and submit to the IRS on your behalf as payment plan. They can also go to your bank account. If you have a merchant account, a business account that is under your name, they can go to investment accounts. I've seen that a lot actually. Bank accounts, you see a little less unless the individual has multiple bank accounts, which I've seen too. And especially if the taxpayer has someone else's name on that, or the taxpayer is not the main person on that. Sorry, the taxpayer has another person on the bank account. I've seen time and time again where the IRS goes and takes part of the portions of the bank account. They leave a certain amount by law, they have to, but now you have money from your spouse or from your children or from someone who may be using the account. Like I said, investment accounts is where I've seen it more and more. The IRS doesn't feel like, if you owe money to the IRS, that you should have an untouched investment account. So they'll go ahead without thinking about it twice, and they go and grab that money. And once the IRS does that, once a levy happens, it is very difficult for you to overturn that. In other words, let's say we're talking about a bank account and the IRS went ahead and took out $2,000. It's very difficult now as a representative to say that, hey, IRS, you shouldn't have taken those $2,000. Now the taxpayer is unable to pay rent or to provide food because the IRS mentality is, look, you had enough time and we sent enough letters for you to respond and for you to work with us. And now that we've taken your bank account or you've taken part of your wages, it's not our fault, pretty much. And the last one is, and I think a lot of individuals, a lot of clients who come to the clinic are very surprised, is the Social Security benefits. So if you have any federal payment benefits that are, that you receive on a monthly basis, the IRS can go ahead and also issue a levy against those. Like I said, a lot of clients that come in with Social Security benefits that are being levied, they don't understand, as many retired individuals whose only source of income is from Social Security. They are in the poverty line, but the IRS can take up to 15%. And this is true too. And something that we need to discuss is if you file a joint tax return, let's say, and now your spouse is deceased or something like that, then, and you're receiving Social Security benefits, the IRS can go ahead and levy that too. Also, if you have widow benefits under your spouse's Social Security, and there's a levy and there's a tax liability and nothing has been done, they can levy those as well. So like I said, the power for the IRS on the levy and the liens is pretty broad. So the most important thing is for you to keep track and to communicate, to find representation. And later on, I'm going to talk a little bit as to what we do at the Low Income Taxpayer Clinic to help and to assist taxpayers in this type of situations. And I'm sorry here, the lien, the most important to know about liens, going back to those tools that the IRS has and the lien power that they have, is that it does show up in some background checks, especially if you're going to be entering the workforce in some financial institutions or something that you're dealing with other people's money. So mortgage brokers, any profession that requires you to have a bond. If you have an IRS lien, unfortunately, you're not going to be able to get that license. So it's something that it's important to know. And it makes it, it also impacts your credit. Also, requesting some loans and stuff like that can be and will be impacted by the liens. We talked about this already a little bit. If you do need to discharge, if you're selling a property that is under that lien, but also there's a lien release. In other words, once the IRS goes actually to the county and takes away that lien from public records. And that is either, like I said, either you paid off the amount that is owed, or the liability is unenforceable. In other words, the 10 years have already passed. The IRS has to, within 30 days of either you paying the liability or the liability becoming unenforceable, they have to go ahead and take that lien out of public record. They're pretty good about doing it. but not 100% of the time. So sometimes you have to go ahead and make that request. I'm giving you here the number for the centralized lien unit. That's the unit that deals with, of course, all liens. And we're lucky enough they're actually here in Florida. They're in Broward County. So usually if it's easy for us once, like I said, once the IRS office, a campus implementation Broward County reopens, sometimes you can meet with personnel and employees from the IRS within this unit and get the relief just a little bit faster to move forward. Another way that you can ask for a lien release is if you enter into an installment agreement. And we'll talk about it just in a few seconds about what an installment agreement is and how to enter into one. And it's a payment plan. So if you enter into a payment plan when you're asking the IRS to withdraw directly from your bank account the monthly installment or the monthly obligation, after 3 payments, you can actually request the IRS to go ahead and release the lien, and they'll go ahead and do that. I've had many taxpayer clients, and I've heard a lot of stories about taxpayers making this request just so they can get it released. And then because they need it for something, usually it's because of work related, they need that lien to be released right away or within the 30 days. And as soon as that lien is released, they go ahead and default on their installment agreement. Like I said, IRS powers of lien and levy are really broad. So the IRS can go back and put that. And if it's a license issue, they can go ahead actually and get that license revoked. Okay, so it's something to also keep in mind. So the levies, going back to the levies and going back to the IRS is not just going to one day surprise you and start taking part of your benefits or taking part of your wages or going into your bank account. The IRS is by law, they must go ahead and send you a letter saying, hey, look, we are going to, this is an intent. It's a demand letter. We're going to intend to levy if you don't do anything within 30 days. And then there's 3 letters. So the first one is saying you owe money. The second one is saying we intend to levy or to lien. And the last one is saying we're doing this. And now the only option that you have to stop this is by doing a collection due process. And you have to do collection due process rights and going through those. There's some the levy or the lien cannot be placed, or the levy more than the lien cannot be placed if you have if you're going through bankruptcy, because the IRS will wait to see if some of your tax responsibility or overdue taxes are going to be part of that bankruptcy. And yes, taxes can be removed or released through a bankruptcy process. Is not easy, and there's requirements that need to be met to be able to do this. But I know a lot of taxpayers, a lot of the community has a misunderstanding that bankruptcy, taxes and bankruptcy do not interact. They do. Like I said, there's some requirements that need to be met, and that's why the IRS will wait for the bankruptcy case to be over before they go ahead and start a levy. If you got that last letter and you decided to go through the collection due process and you requested a hearing, a collection due process hearing or equivalent hearing, which we'll talk about, if you've entered into an installment agreement. So if you're making payments, the IRS, even if it's $20 or $5 towards your liability, the IRS cannot go ahead and levy. Of course, if you owe money for multiple years and you enter a payment plan for only part of those years, so for year 1, 2, tax year 1, 2, and 3, but not for 4, 5, and 6, then the IRS can go ahead and levy because of those other tax years. So you need to make sure that you call the IRS and say, look, I need you to add all the tax years that I have in liability into the installment agreement. Also, if there's an offering compromise out there. An offering compromise is pretty much, and we'll talk about it just a little bit more in detail later on, but it's when you're asking the IRS, you're offering a lower amount of what you owe to the IRS. So while they're making that determination whether to grant that offer or not, They cannot levy, the IRS cannot take any collection action. The only thing that they can do is use your own tax return refund to offset any liability, but they cannot take any other collection action against you. And also, if you are requesting, or you've submitted a request for innocent spouse relief, and that's when you file a joint return. Let's say I filed a joint return with my husband in 2015, and due to the circumstances of the marriage, is not equitable to hold me responsible for any liability from that tax return. Usually these are taxpayers who are in a domestic violence and they're survivors of domestic violence, or there's any domestic violence in the relationship. That can be, that usually are the ones who are granted this type of relief. So what is a collection due process hearing? This is good for either a levy or a lien. So if you get those letters saying, hey, we're going to be placing a lien or a levy against you, you have 30 days from that final notice. And this is so important, 30 days. Deadline, 30 days, again, I say, to go ahead and make that request. You make the request. There's a letter, and there's actually the IRS will send you the form that is listed here, the 12153. You have to fill that within 30 days and submit to the IRS. Then they'll go ahead and contact you with a date for the hearing. And if you file within the 30 days, again, this form, and you request the CDP hearing, then the good thing about it is that if after the hearing, the IRS still doesn't agree with you and they still want to go ahead and move forward with the lien or the levy, you can appeal that. And if the appeals officer still says, let's move forward with the lien or the levy, you have an option of taking it to tax court. You can still, so if you don't file within the 30 days, you can still make a request for a hearing, but it's not a CDP hearing or collection due process hearing. It's called an equivalent hearing, means it's almost like a CDP, it's almost like a collection due process hearing, but not quite there. So if in that hearing, once again, the IRS says, look, we're going to move forward with the levy or the lien, then you can appeal that because it's still within the IRS. However, if the appeals officer still agrees with the IRS and not with your position, you cannot have judicial review and have the tax court hear your case. So that's why it's so important that if you want that option, you want to keep that door open of going to tax court and having an impartial judicial review, then within 30 days, go ahead and file your collection due process hearing notice. Okay. For the appeals, there's a couple of things that need to be, what happens. So you go through the hearing, let's say, and the IRS still says, no, we're going to move forward with the lien or the levy, then you can appeal that decision. There's a couple of things that you need to do, is that you need to make sure for the appeals that you have to file you must have filed all your tax returns that you're required to do so. So you need to be in what is called filing compliance. And for a lot of the alternative collection options that we're going to discuss a little later on, alternatives, and I have them listed on this a slide, you must be in filing compliance. If you're not, then it's an automatic, sorry, you don't qualify for this. We're going to move forward with collection against you, okay? You also have to fill out a form 433A, is pretty much a financial affidavit where you have to show and list with proof all the income you have to, that you have in the household, all your expenses, living expenses, rent, all that. What you want to do for that is you go to the irs.gov website, so irs.gov as in Victor, and you look for the national collection standards. The IRS allows some of these expenses, such as food, transportation. They allow a number without you having to really prove it, and it goes by the number of family members in your household. So if you live by yourself, then the numbers are 1. If it's a household of 2, and so forth. And that's going to be beneficial because In some of the areas, the IRS or the national standards, I'm sorry, are very generous, especially for food for a single person. Let's say, I think they give up to almost $400 worth of food expenses, personal care. So meaning, all those personal items, personal care items, I think it's $100. So it's pretty generous. It's probably more than the taxpayer actually has in expenses. So you have to fill out this form for the appeals, and you have to show in the appeal saying, look, the lien and the levy shouldn't be placed because I am going to go through another collection alternative. So I'm giving you another option, IRS, and I'm willing to start paying, or I'm willing to start working on the overdue taxes that I have, either through a currently non-collectible status, a payment plan, or an offer in compromise. Okay. So once the determination happens, if you did file that on time, then you can go to tax court. If you don't, if you didn't file on time, unfortunately, now you are stuck with the appeals decision. And like I said, either the lien or the levy are going to start taking place. If you are within those, you did file within the 30 days, the CDP notice, you can go to tax court. Again, there's going to be a letter that is sent to you. You only have 30 days to file a petition with the tax court, which is a little bit less time that you normally have when in the beginning, if the IRS did an examination and you get what is called notice of deficiency, you have 90 days to file a tax court petition. And tax court petitions, you have to adhere to their deadlines. There's a black and white deadline. There's nothing like, oh, I forgot, or I was sick, or I was in the hospital. Unfortunately, when it comes to these deadlines, the tax court is very, very strict. And then you can have tax court go ahead and hear your case. Usually what happens is that your IRS counsel gets involved. They usually send it back to appeals for one more chance to see if you can go ahead and negotiate or come to some understanding. Then you can work with IRS counsel to see if they are willing to work with you. And if nothing works in your favor, you can go ahead and have a hearing and have a trial with the judge. I want to move forward a little bit more because we are running a little bit out of time, and I really want to spend the last few minutes talking about collection alternatives. So what happens when, whether it's a math error, or you file a tax return that has a liability, or there's an examination that determines that you owe money, or there's a substitute for return. And even if you file your own tax return, you're still going to owe money to the IRS, and you don't have the means of paying what you owe in taxes. These are the three alternatives available. So we're going to go through each one. The installment agreement is a payment plan. You go ahead and file a Form 9465. There is a charge to enter into installment agreements of $186. However, if you request the IRS to do a direct withdraw, from your bank account on a monthly basis, it's only $43 to enter into an installment agreement. Also, if you can certify as low income, and there's a form that needs to be filed. Most of the time, the IRS will do that automatically too. That is $43. Also, if you enter online into the installment agreement rather than mailing the 9465, then the fee is also reduced to the same amount. Usually what you do is you total the amount that is owed, you divide that amount by 72. So 72 months, 72 payments, and that's your minimum payment obligation. If the obligation is too high, and in a lot of cases, I've had taxpayers whose levy is less than their minimum installment agreement. Usually then we let the levy stay rather than entering into an installment agreement. However, if you are in one of those cases, but you just financially, you cannot make the minimum payment, then you can make a request for a lesser amount, a lesser monthly obligation, but you need to go ahead and send the same form that I talked about before, the form 433A, which is the financial affidavit. Once again, you show all your income, all your assets, or your everything, or your expenses, and then submit to the IRS, and they can show that it's impossible for you to be able to pay for your personal expenses or your basic living expenses, and also make an installment agreement, and the IRS can reduce the amount at that point. Okay. One thing to know is that if you don't, the IRS, once you enter into an installment agreement and you, let's say 1 month, you just can't make the payment. It happens. There's an incident that, something that you unforeseeable, your car breaks down, something like that, and you don't have the means, you can always call the IRS and say, look, only this month, even if you have a direct withdrawal, say IRS, my financial situation for this month changed a little bit. Can I skip this month? If you talk to them, they'll go ahead and put a note on your account, and they're able to and willing to make that. Of course, if you do that every month or you do that often, it's going to come to a point that the IRS says, maybe you need to reevaluate whether the installment agreement is the best collection alternative you have. The second collection alternative is currently non-collectible status. Okay, so the currently non-collectible status is pretty much telling the IRS, I owe you money. I do, but there's no way that I can make any payment. I cannot even enter into a $5 installment agreement. There's two ways of doing it. If you are unemployed and you have no income, or unemployment benefits are your only income, you can call the IRS, speak to an IRS representative, speak to them, let them know what your financial circumstances are. And on the phone, if you owe less than $50,000, so 50, they can go ahead and place the currently non-collectible status right there and then. So if you're unemployed, okay? Same thing if your only source of income is from Social Security benefits. That's another way that you can just pick up the phone, call the IRS, say my only source of income is from Social Security benefits, and they'll go ahead and place your currently your account on currently non-collectible status. So in this status, or this protective status, the IRS just do all the money. The interest will continue to accrue, something that you need to understand, that it is going to continue to grow. However, the IRS cannot take any collection action against you. They cannot levy you. They cannot place a lien. Actually, they usually will place a lien against you. So they cannot levy you. They also can and will take any refunds that are due to you. So if you file a tax return and there's a refund that's due to you, they can go ahead and use that to offset it. So this currently non-collectible status only protects you for the levy. You also will get some letters from the IRS, especially the annual reminders. Every single year, the IRS wants to remind you, if you're in the special status, that you owe money to the IRS. So they'll send you a little letter and it says annual reminder, hey, remember, you owe us money. So if anything changed, you can go ahead. Also, there's a couple of things that can get your account removed from the status. One of them is not filing your tax returns. So unless you're on Social Security benefits, if you don't file your tax returns, then the IRS doesn't know whether your account should still be granted this protective status. Okay, so you must file your tax returns. Another way is if you do file your tax return and you made more than the poverty line, and they have it's 250% above the poverty line. So if you made more than that, now the IRS says, now we know that your account is collectible, and therefore you need to either enter into an installment agreement or explore our last collection alternative, which is an offering compromise. And when I talk about this alternative with my clients, I can see like a little hope in their eyes, saying maybe this is the perfect option for me. And they leave the office happy because maybe this is an option for them. I have clients cry when I kind of explain to them what an offering compromise does. So I'm gonna make myself as an example. Let's say let's go back to the $5,000. I owe $5,000 to the IRS, and I wanna go ahead and maybe explore whether an offering compromise is an option for me to reduce the amount that is owed and to pay a little less to the IRS. So there's a couple of things. Let's say I owe the money because the IRS assessed a penalty against me, you know, or something like that. And I don't think it's right, but, you know, I don't have other means of fighting the assessment because, you know, maybe the statute limitation for fighting it, it has lapsed, or I don't have the means of going to circuit court. In many cases, you have to pay before, you know, you can't go to tax court. In some cases, you have to go to circuit court, and I don't have the means of paying it. So now I'm doing an offering compromise saying, look, IRS, you're saying that I owe this money. I doubt the liability. I don't owe the money. I'm going to prove why I don't owe you the money. And then I'm going to make you an offer. Rather than paying $5,000, I am going to offer you $100, let's say. And of course, that is driven by my finances, my financial situation. If the IRS looks at the case, they say first they have to see whether you really owe the money or not. If there is a doubt as to it, then they're going to look at my financial situation. And then if they agree, I pay the one time $100, and then the rest, $900 goes away. So let's say that's not my scenario. I owe money because I made a mistake on my tax return, or I didn't file my tax return, or I was self-employed, or I had a small business, whatever it is. But I actually do owe the money, and I know this. I know that I owe the $5,000. But my financial situation is such that I'm going to say, hey, IRS, I'm not collectible. You can't collect anything from me. You know, even if I try to enter into a installment agreement, my best option is place me in currently non-collectible and not ever see a penny, or I can offer you, once again, let's say $100, and for the $100, everything else goes away. This is a great option, or this is an option for individuals who's, you know, unfortunately, if you own a home, this option is usually not available because, you know, you may have equity in the home. If you don't have equity on the home, then it's a good option. But the IRS mentality when it comes to offering compromises, especially during this pandemic period, we've actually, this week, we've been talking to other clinics around the country. We're having our annual conference for our clinics. And a lot of clinicians who are in the same position as me around the country are saying the same thing, that offering compromises during the pandemic have become more and more difficult. So it's something that I'm very surprised. Usually the IRS will take the different stand during financial hardship through the country or through an area. And this time they've actually taken the different approach, and if you can pay $1 more, they're going to fight you with it for it. Another one is, so the third one is a status to collectability with special circumstances. And that is the individual who has enough income and assets to enter maybe to an installment agreement, or to pay the amount that is due, or to, let's say, I have an investment account where I have $4,000. According to the IRS, I should cash out the investment account and send them the money. But I can say I have special circumstances. Let's say that, you know, 60 years old and 65 years old, I'm retired, and that's the only savings I have, Social Security benefits and that little investment account. That's all I have. So I can always make that, that argument, hey, IRS, I have special circumstances, even though according to the offering compromise rules, you should take 80% of whatever I have in my investment account. I am claiming special circumstances. Like I said, these cases are a little bit more difficult to go through or to pass, but we've always had very good luck. Even people who own homes that have a little bit of equity, it just depends on the circumstances, and each taxpayer has, it's a different world, so different arguments need to be made, but we've been able to be very successful with offering compromises. In our clinic, we so far have 100% of the offers that we've submitted have been accepted by the IRS. Sometimes I have to push back and say, no, you know, you're not looking at the numbers correctly. We've had to go sometimes through the appeals process, but we've been, like I said, we've been extremely successful, and and with this option. So if you have any questions, I'm giving you my information here or a phone number. Like I said, my name is Kathy Guerra. I also, my paralegal is Maria Romero, and you can always call if you have any questions, if you have any doubts. I want to invite you again in a couple of weeks. We'll be spreading the word about having our local taxpayer advocate, and see if we can gather other tax professionals around the area as you're preparing for the 2020 tax season. The important things to know that, economic impact payment is one of the big issues that we need to discuss. And for those who haven't received it and are eligible, to get the information that you need to be able to go ahead and claim that on your 2020 tax return. I hope this was educational and worth your time. Thank you.